Good evening. How's everybody doing? Great to be learning with you on a Thursday, Yom HaMishi. Let's light up the darkness. Who's in the house? Stephen in New Hampshire, Yehuda in South Carolina, Nancy in North Carolina, Sharon in New Jersey, Bill in mid-Missouri, Lucy in Minnesota, Bella in Florida, Melissa in Great Neck, Paul in the Great Northwest, John in Maine, Joe in the Inland Empire, Shandor in the Bronx, Belle in Texas, Ella's in the house, and Lynn, what was the Hebrew name? I forgot. I can't remember right now. But Lynn in Maryland. Welcome. Ilanit, right? Welcome, everybody. Good to have you with us. We're continuing our progress through the final chapter, chapter 10 of Tractate Bava Kamma, the 21st volume of the Talmud. Our daf is page 112. We're going to pick it up somewhat near the top of page 112a. And we're continuing our discussion of Mishna number 1 here in chapter 10. So this is one who robbed and then died, right? And so his children inherited what he robbed. And what are we going to do? How do we dispose of that property? Do the children have an obligation to return what they inherited, given that it was stolen by their father? The sages taught in a baraisa with regard to one who robs another of food and feeds it to his children. The children are exempt from paying the owner. In a case where he left stolen items to them as an inheritance, if the heirs are adults, they are obligated to pay. And if they are minors, they are exempt from paying. If the adult heirs said, "We do not know what calculations our father made with you," the robbery victim, "and whether he paid you for the stolen goods," they are exempt. The Gemara expresses surprise. Because they say, "We do not know," they are exempt? Since it is clear that they are in possession of stolen property, how can they be exempt due to the uncertain claim that perhaps their father repaid the owner after the theft and before he died? So Rava said that the heirs are certain about their claim, and that the baraisa should be formulated a little bit differently. And this is what the baraisa is saying. In the case of adult heirs who said to the claimant, "We know the calculations our father made with you, and there is nothing of yours left with him as he paid his debt to you," they are exempt. Now it is taught in another baraisa with regard to one who robs another of food. And now remember that this is in the absence of the robbery victim bringing witnesses who say that man stole from you and that's the property, right? It's established through the testimony of witnesses. This is a guy who comes to the court and says, "That's my property," right? And the heirs don't contest that. They say, "Okay, well, that might be yours. I understand that our father took it from you, but he paid you. He already made restitution, or he bought it from you. Maybe it was yours. Maybe our father bought it from you," right? So it's not being clearly established through the testimony of witnesses. It is taught in another baraisa with regard to one who robs another of food and he feeds it to his children. The children are exempt from paying. If he left stolen items to them as an inheritance and they consume those items, whether they are adults or minors, they are obligated to pay the owner. And because they benefited from it, right? So the Gemara asks, are minors obligated to pay? Let it be only like a case where one caused damage, and the minor who causes damage is exempt, right? A minor is not legally responsible for his actions. Rav Papa said that the baraisa should be formulated differently, and this is what the baraisa is saying. If he left the stolen items to them, right, to his heirs, to his children, as an inheritance, and they did not yet consume them, whether they are adults or minors, they're obligated to return the stolen items. Since the items are still extant, they can't become part of the estate. They never belonged to the father in the first place. Rava says, in the case of children whose father died and left them a cow that he had borrowed. Now remember that there's 4 categories of person who is legally in possession of the property of another, and that's the paid bailee, the unpaid bailee, the renter, and the borrower. And the Torah mentions all four specifically, and they have different levels of obligation, meaning different levels of liability, if the item is damaged due to unavoidable circumstances, stolen by armed bandits, lost, negligently damaged, etc. Right? So they have different levels of responsibility. So now we're talking about a borrower. The father was a borrower. So Rava says in the case of children whose father died and he left them a cow that he had borrowed, so they may use it for the entire duration of its loan, right? It was legally in the possession for a period of time, in the possession of the father. He died. The children, as his heirs, can continue to use the cow for the legally permitted duration. In other words, for whatever the contract, whatever the terms of the borrowing were by the father. Nevertheless, if the cow died, they are not liable to pay if its death was caused by an unavoidable accident, despite the fact that a borrower is liable for damage caused by an unavoidable accident. And this is because liability for accidental damage pertains only to the actual borrower. So interesting that they can step into the father's shoes to continue to use the cow for the length of the loan, but if the cow is damaged due to unavoidable accident, the father would have been liable to pay for that, but the children aren't, since they did not enter into that agreement. Right, this is because the liability for accidental damage pertains only to the actual borrower, i.e. the deceased father. So if the children thought that it actually belonged to their father, and they slaughtered it and ate it, right? They didn't think they were misappropriating it. They thought that it was their father's cow, and then he died, and they inherited it. So it was their cow, and they slaughtered it and ate it. In their mind, they didn't do anything wrong. In that situation, they are liable to pay the owner the value of the meat. But what kind of meat? Inexpensive meat, right? So they consumed it. So now that it turns out that it wasn't their cow to eat, they are going to have to pay it, but they're going to have to pay for it at the lowest level that you can indemnify one. And what is that? Inexpensive meat. What does that mean? Basically 2/3 of the market price of meat. Rava adds, if their father left them guaranteed property, which means land, then they are liable to pay, right? They have to cough up the land or actually pay its value. The Gemara comments, some teach this final statement of Rava with regard to the first clause, which states that the heirs are exempt from payment for accidental damage. So according to this interpretation, if the father left them land, they are obligated to pay for the cow if it dies due to unavoidable accident, right? They have other assets, hard assets, land, so they can pay. And some teach it with regard to the latter clause, which states that the heirs who slaughter and consume a cow must pay the owner the value of inexpensive meat. So according to this interpretation, if the father left them land, they must pay for the full value of the cow. Now, the one who teaches it with regard to the first clause holds it to be true all the more so with regard to the latter clause, where the heirs actually consume the meat themselves. And accordingly, this understanding differs with the forthcoming opinion of Rav Papa. By contrast, the one who teaches it with regard to the latter clause holds it to be true in that clause exclusively, but with regard to the first clause, it is not true. And this is consistent with the forthcoming opinion of Rav Papa. As Rav Papa says, if he had a stolen cow in his possession and he slaughtered it on Shabbos, he is liable to pay because he was already rendered liable for the theft before he came to transgress the Shabbos prohibition of slaughtering an animal on Shabbos. But if he had a borrowed cow in his possession and he slaughtered it on Shabbos, he's exempt from payment, as the transgression of the Shabbos prohibition of slaughtering an animal on Shabbos and the prohibition against theft occur at the same time, at the same moment. And the act of slaughter is tantamount to the theft of the animal. And this indicates that according to Rav, now why wouldn't she be liable both for the theft of the cow and for violating Shabbos? Because technically, violating Shabbos, if you intentionally violate Shabbos, is a death penalty offense. It's never enforced, but technically it is. And if you become liable to two penalties simultaneously, the Jewish principle is you're only going to be subjected to the bigger penalty. So since it would be the death penalty, you'd get off on making that restitution for the theft. Now, this indicates that according to Rav Papa, a borrower's liability to pay for accidental damage is initiated only when the damage is inflicted. Accordingly, in the case discussed by Rava, since the damage was not inflicted during the father's lifetime, the deceased's property was never liened to the cow's owner, and consequently, the heirs are not obligated to pay for any accidental damage. After having cited two baraisas that express different opinions with regard to the obligation of heirs to pay for property stolen by their father who then died, the Gemara cites a third baraisa that presents both opinions. So the sages taught with regard to the verse, then it shall be, if he has sinned and is guilty, that he shall restore the item that he robbed. Right? That's the source for all of this making restitution after robbery. Recall that robbery is distinguished from thievery. A thief steals and humans don't know that he did it. God knows. A robber steals and both God and the humans know that he did it. He was visibly the one who stole. The thief thought he got away with it because no one saw him. Right? So here we're talking about robbery. So then it shall be, if he has sinned and he is guilty, that he shall restore the item that he robbed. Leviticus 5:23. Now, what is the meaning when the verse states that he robbed? It means that the robber must return the same item that he robbed. Now, from here, based on this exposition, the sages stated, in a case of one who robs another of food and he feeds it to his children, the children are exempt from paying the owner because the food doesn't exist anymore. If he left stolen goods to them as an inheritance, whether they are adults or minors, they are obligated to return the stolen goods. And they said in the name of sumachos, if the heirs are adults, they are obligated, but if they are minors, they are exempt. So the Gemara recounts a related incident. The son of Rabbi Yirmiyah's father-in-law, so it sounds like it's Rabbi Yirmiyah's brother-in-law, right? The son of Rabbi Yirmiyah's father-in-law, i.e. his wife's brother, who was a minor, shut the doors of his father's house before Rabbi Yirmiyah in order to prevent Rabbi Yirmiyah from establishing legal possession of the house or a chamber that he claimed belonged to him. So Rabbi Yirmiyah came before Rabbi Avin to file a legal claim against his brother-in-law. So you get the picture. Rabbi Yirmiyah has a wife. Rabbi Yirmiyah had some business dealings with his shver, as they say in Yiddish, with his father-in-law, right? His wife's father. And now the father died. And, you know, he was in possession, the father was in possession at the time that he died of some property of Rabbi Yirmiyah that was in his house. And who is the heir of Rabbi Yirmiyah's shver, of his father-in-law? His brother, Rabbi Yirmiyah's brother-in-law, his wife's brother, right? So his wife doesn't inherit because males inherit under this kind of law. So that brother who's a minor, he is the heir of Rabbi Yirmiyah's father-in-law, and he's got this property that's now in his possession that Rabbi Yirmiyah says, that's my property. Okay, so that's the setup. And the minor son who inherited doesn't want Rabbi Yirmiyah to come in and take this property. So he closes the door and says, you will not enter. You shall not enter. So Rabbi Yirmiyah came before Rabbi Avin to file a legal claim against his brother-in-law, the minor. And Rabbi Avin said to Rabbi Yirmiyah, your brother-in-law is claiming ownership of that which is his, since he retains the presumptive ownership of his father's house and its contents upon his father's death. So Rabbi Yirmiyah said to him, but I can bring witnesses who can testify that I took possession of it during his father's lifetime. And Rabbi Avin said to him, but does the court accept witnesses who testify in the absence of a litigant? Since the defendant is a minor, his presence is not legally recognized, and the court does not accept testimony against him. Come back when the boy is of age. Rabbi Yirmiyah questioned this assertion. And is it so that the court does not accept such testimony? But isn't it taught that if a robber leaves stolen goods to his children, whether they are adults or minors, they are obligated to pay the owner? And if the court obligates minors to pay, then it must accept testimony about them. So Rabbi Avin said to Rabbi Yirmiyah, Sumakos dispute is at your side, i.e. Sumakos disagrees with this ruling and holds that the minors are exempt from paying. Rabbi Yirmiyah said to him, did the whole world go to the effort to hold in accordance with the opinion of Sumakos in order to seize what is mine? Sumakos' opinion is a minority opinion. Why are you holding it up against me? Now we're on page 112b. In the meantime, the matter circulated and eventually came before Rabbi Abahu, who said, did you not hear that which Rav Yosef Bar Kamma says that Rabbi Oshaya says? As Rav Yosef Bar Kamma says that Rabbi Oshaya says, with regard to a child who took his slaves and descended into the field of another person and said, it is mine, meaning that field is mine, and he took possession of it. The court does not say, meaning not he just stole it, right? But he had a legal claim to that field, and so he went and seized it. That's why he brought his slaves with him for the act of seizing the field. It is mine. But the court does not say, let us wait until he matures before we assess his claims. Rather, the court removes it from his possession immediately. And when he matures, he may bring witnesses to attest to his claim, and we will see how to judge the case. So similarly, Rabbi Yirmiyah should be awarded the disputed property until his minor brother-in-law may litigate in court, since Rabbi Yirmiyah has some kind of a strong claim. Maybe he even, and he says he has witnesses. So let the property rest with him. And then the minor son of Rabbi Yirmiyah's father-in-law, who is the inheritor, when he comes of age, he can come to the court and try to remove it from the possession of Rabbi Yirmiyah if he thinks that Rabbi Yirmiyah's claim is somehow false or weak. The Gemara rejects Rabbi Abahu's assertion. Is the case that Rav Yosef Bar Kamma is discussing, is that case comparable to the case of Rabbi Yirmiyah? It is there in Rav Yosef Bar Kamma's case that we seize the property from him, from the minor, because there is no presumption of ownership from his father. But where the minor has a presumption of ownership from his father, like the son who inherited from Rabbi Yirmiyah's father-in-law, no, we do not seize his property. Since Rabbi Yirmiyah's brother-in-law has a presumption of ownership due to the fact that the property formerly belonged to his father, he retains control of the property, and Rabbi Yirmiyah will have to wait until he becomes of age, and then he can come to the court and bring a case against his brother-in-law. Having mentioned the issue of testimony in the absence of a litigant, the Gemara discusses the matter in greater detail. Rav Ashi said that Rabbi Shabtai says, the court accepts witnesses even in the absence of a litigant. Absentee defendant, right? We don't like it. We don't like it. Certainly, we don't want to pass, a judgment that's going to result in some kind of criminal punishment, God forbid, a death penalty, in the absence of a defendant who can't speak for himself, can't defend himself, can't bring witnesses, to defend his case. Of course, we don't want to litigate in the absence of the defendant. On the other hand, if a defendant absconds so that the trial can't proceed because he's not there, are we going to let him get away with that? So you can see there's two sides to why we would or would not allow a case to proceed in the absence of the defendant. Rav Ashi said that Rabbi Shabtai says the court accepts witnesses, even in the absence of a litigant. Rabbi Yochanan wondered at this statement of Rav Ashi and said, does the court in fact accept witnesses in the absence of a litigant? And Rabbi Yosef Bar Chanina received the following guideline from Rabbi Yochanan. The court accepts testimony in the absence of the defendant only in a case where the plaintiff was ill, or his witnesses were ill, or his witnesses wished to travel overseas and the judges sent for the defendant and he did not come. Since there is a concern that the plaintiff will not be able to present his claims at a later date, the testimony is accepted even in the absence of the defendant. Does that mean that a verdict is reached? No, not necessarily. Just that we accept the testimony of the witnesses, because if we don't accept it now, the judges will never be able to hear it. Rav Yehuda says that Shmuel says the court accepts witnesses in the absence of a litigant. Mar Ukva says this statement was explained to me personally by Shmuel himself. And he said that it applies in a case where the court opened his case and sent for him, but he did not appear. The plaintiff brought the case, opened the case, sent in his witnesses, and then the plaintiff didn't show up. You would think, well, let's cancel the case. But if, he was held up due to circumstances beyond his control, excuse me, it's not that he was disrespecting the court, but something happened. His witnesses are ready. If we don't hear the witness's testimony now, maybe we'll never hear it. Okay, so we'll hear the witness's testimony, and then the case will continue later. But if the court did not yet open the case for him, he may say to the plaintiff, I am going to the high court to resolve this case, and I will not appear in the local court, right? Once the case is open, okay, the judges can hear witnesses. But if the case has not been open yet, and the defendant says, you know what, I don't submit to the authority of this court. I am taking this case, I will have this case judged in a higher court. Then we might let him do that, right? We don't have the same kind of civil procedure, appellate procedure that we have in American, state and federal courts, where you have to start in a trial court and then go to an appellate court and then maybe a Supreme Court. Here, it was possible under certain circumstances to go to a higher court. Now, the Gemara asks, if so, then even when the court already opened the case for him, he should also be able to say to them, I'm going to the high court to resolve this case. And the Gemara answers that Ravina said the defendant may not defer an opened case to the high court if, for example, the local court obtained a license from the high court authorizing it to adjudicate the case, right? So it's a little bit less defined when it has to be adjudicated in the local court, when it can go to the higher court, let's say the Sanhedrin in Yerushalayim, or a bigger, a higher court that's a regional court, something like that. It's not always exactly clear when you can go to which court, but the sages will consult with each other. Having discussed testimony that's heard in the absence of a litigant, the Gemara addresses a similar matter. Rav says, the court ratifies a document in the absence of a litigant, right? So a promissory note, a deed to land that was drawn up by a scribe at the time that there was a loan made or land was sold, and witnesses signed the document. And now it's going to be a contested document. We can ratify that document, meaning bring in the witnesses who signed it and say, is that your signature? Were you present when this document was signed? That's ratifying a document. There's various different ways that a document can be ratified, but it sounds like that we can do even in the absence of the litigant. Then Rabbi Yochanan says, the court does not ratify a document in the absence of a litigant. Machloket, right? Or machlokes, a dispute. A disagreement among the sages. Rav Sheshis said to Rabbi Yosef Bar Abahu, I will explain Rabbi Yochanan's reasoning to you. The verse states with regard to an ox that gored, how we started this tractate. And warning has been given to its owner, and he has not secured it, meaning he has not secured the ox that is now understood to be a muad, right? A forewarned ox, an ox that has done damage in the past. So now its owner has a higher level of responsibility to safeguard it from causing damage again in the future. So the Torah means to say, let the owner of the ox come and stand by his ox when the testimony about the ox is provided. Similarly, a document may be ratified only in the presence of the individual that it implicates. In other words, a forewarned ox, that means that its owner was warned. Who warned him? That is an actual legal procedure of warning the owner. A court does it, or perhaps it was done not by a court, but by the victim or by some, I think maybe it has to be the court, but at the very least, it would have to be done in the presence of witnesses, right? So that's a legal procedure. And we can't just say, well, everyone in town knows that ox, gored on previous occasions, and now he went and did it again. So you're going to have to pay the penalty now that it gored again of a forewarned ox. No, unless we have established legally that the owner heard that warning, it's not a forewarned ox. Rava said, and likewise, so we're going to learn out from that law that to ratify a document, Rabbi Yochanan would say, to ratify a document, also you have to do that in the presence of the one that the case is going to be brought against him. Using this document, ratifying the document has to be done in his presence also, because maybe he'll bring witnesses to show that the witnesses who are ratifying the document are actually conspiring witnesses. You got to give him that chance. Rava said, the law is that the court ratifies a document in the absence of a litigant. And this is the case even if the other litigant stands and screams in protest that the document is a forgery. And if he said, give me time until I bring witnesses and disqualify the document, we give him time before forcing him to pay. If he has come with witnesses within the time allotted to him, he has come. And the court reviews the case accordingly. And if he does not come within the time allotted to him, we give him an additional 3 days on which to bring witnesses when the court is in session. The courts were in session on Monday, Thursday, Monday. So we give him 3 times that the court was in session to produce his witnesses to show that the document is false, to contradict the testimony of the witnesses who said that the document was true. And then, basically, if he blows off the time limit, okay, well, then he did not establish that the document was false. We are going to take it that it's true by the testimony of the witnesses. We ratified it, and now we can use it against him, and he'll have to pay. If he still has not come, we write well, wait a minute. If he still has not come, I jumped the gun there. They said, okay, you have this Monday, this coming Thursday, and next Monday to produce your witnesses to show the document is false. And he said, I will come. And then he doesn't come. So what happens? If he still has not come, we write a document of ostracism against him for 90 days. Right? So he's not going to be able to bring other cases, possibly not even do business with other Jews in the town. So we write a document of ostracism. Let's see, a document of ostracism. This is a court summons that is delivered with a notice that if the summoned party does not appear, the court will issue a writ of excommunication against him. And since this document is the opening measure that the court takes to coerce the litigant to appear, it is called a peticha, which means opening. An individual who continues to avoid the court's summons may be subjected to further, more severe measures like excommunication, meaning that no one in the town will do business with him. So it's a threat that has some bite. Okay, so this guy said he was going to produce witnesses and he hasn't showed up. So if he still has not come, we write this document of ostracism against him for how long? For 90 days. Why 90 days? During the first 30 days, we do not descend to his property to collect his debt. As the court says, perhaps he is occupied with borrowing money to pay his debt. And during the middle period of 30 days as well, we do not descend on his property and take it. As the court says, perhaps he did not find someone to borrow from, and he is now occupied with selling his property in order to pay his debt. And during the final 30 days as well, we do not descend and seize his property. As the court says, perhaps the debtor has found a purchaser, and the purchaser himself is occupied with obtaining the money so that he can pay the debtor for the field, let's say, that he's buying, which the debtor will then use the proceeds of that sale to pay off the debt that is the subject of the case, right, in which we ratified the contract or the promissory note against him. Now, after 90 days, if the debtor still did not come to pay, we write a document of authorization, an adrachta, allowing the creditor to collect his due from any property belonging to the debtor. And this statement applies only in a case where the debtor said, I am coming to pay, but then he does not actually appear in the courtroom. But if he said, I am not coming, well, then we immediately write a document of authorization without waiting for 90 days to pass. Right? If he defies the authority of the court, says, I won't pay, well, then the court imposes its authority on him. If he says, give me time, so we give him time. But when the time has elapsed, then the court steps in. Furthermore, this matter of a 90-day waiting period applies only with regard to a loan, as the debtor requires time in order to obtain the money to pay it back. But with regard to a deposit, right, if the plaintiff had deposited property with the defendant and now wants his property back, right, that's different than that the defendant borrowed money and now has been slow or reluctant to pay back. That's a little different. But with regard to a deposit that the owner demands back from a bailee, we write a document of authorization immediately. Since the bailee should have immediate access to the deposit, there is no reason to grant him an extension. The Gemara adds, when we write a document of authorization to go seize property, the document applies only to the borrower's land. But with regard to his movable property, the court does not draft such a document. And the reason for this is that perhaps the creditor will seize and consume the borrower's movable property. And when the borrower later comes and brings those witnesses and invalidates the creditor's document, he will not find anything to collect in order to retrieve his money. Right? So the creditor can use the court's writ of authorization to seize land, because if it turns out that the creditor is lying or has a falsified document, perhaps he didn't even know that, well, then we can undo the seizure because the land is still there. But if he seizes movable property, he might sell it, consume it, who knows what. And then when the defendant who had this property wrongfully seized from him finally gets around to proving that it was wrongfully seized, it will be gone. So the court doesn't issue a writ of authorization for movable property. And if the creditor owns land, we write a document authorizing the creditor to collect from any property that belongs to the borrower, including movable property, because if it turns out that the movable property was seized wrongfully, okay, well, the creditor has land. He'll be able to make good on what was seized wrongfully. Since the creditor owns land, there is no concern that if the borrower manages to overturn the ruling, he will have nothing from which to collect. And the Gemara comments, and that is not so. The court does not draft a document of authorization with regard to movable property, even if the creditor has land. And this is because we are concerned lest the creditor's land depreciate in value and the borrower will be unable to retrieve his money. And the Gemara teaches another halacha, another law, with regard to this matter. When we write the document of authorization, we inform the party that is liable to pay as a final warning before authorizing a creditor to locate and take possession of his property in repayment of the debt. And this matter applies only when he is nearby. But if he is distant, the court does not notify him before authorizing the creditor. And if he is distant, but there are relatives of his nearby, or if there are caravans that go to the borrower's current location and return, so we delay issuing his document of authorization for the 12 months of the year until the caravan goes and returns, so that if he wishes to make a claim, he can do so. And this is like that incident where Ravina delayed for the 12 months of the year before issuing a document of authorization for Mar Acha until a caravan went and returned from Bei Chozai. from Bechozai. Now the Gemara comments, and that is not so. You can see that different jurisdictions, as it were, right, different locales under the authority of different local rabbis, sometimes had different, not different halachas, but different, let's say, laws of civil procedure, or different, rules of civil procedure, not actual laws. And this is not so. There, Ravina delayed issuing the document because the creditor was a violent man. And if a document of authorization would come into his possession, it would not be possible to take it from him if the borrower would prove that the original document was invalid. But here, in general, we wait for the defendant to be informed only if he is close enough to be informed within a day. Consequently, if the court decided the issue on a Monday, a messenger would go inform the defendant on Tuesday, and he would come from his location to the court on Wednesday and stand trial on Thursday. If a debtor is more than a day's travel away, however, the court does not trouble itself to notify him. Apropos the Gemara's discussion of summoning an individual to court by means of a messenger, the Gemara discusses this issue in a more general manner. Ravina said, we deem the agent of the rabbis who was sent to summon an individual to court as credible as two witnesses if he says that the defendant refuses to come to court. And this matter applies only with regard to excommunication. But with regard to issuing a document of ostracism, since it causes the defendant loss of money, as he must give money to the scribe for drafting the document, no, the agent is not deemed credible for this. And additionally, Ravina said, we may give a defendant a particular time to appear in court by informing him of the trial by word of mouth from a woman or from his neighbors, as these people are trusted to notify the defendant of the court's summons. And the Gemara comments, and we said this only where the defendant is not in the city. But if the defendant is in the city, the court does not ostracize him for failing to respond to summons conveyed through a woman or a neighbor. As we say, perhaps they did not tell him of the court summons. As they said to themselves, since the defendant is in the city, a court agent has already found him and told him. And as a result, these unofficial messengers will not deliver the court summons to the defendant at all, and we cannot assume that they did deliver it. We're going to get a little bit of a head start on tomorrow's daf, since tomorrow's class is Friday. So we're on page 113a. And similarly, we said that the court will ostracize one who does not respond to a summons conveyed through a woman or a neighbor, only in a case where he does not pass by the court's entrance on his way home. But if he does pass by the court's entrance, the court does not ostracize him. And this is because it is possible that the unofficial messengers will say to themselves, since he passes by the courthouse, the court has already found him and told him, we don't have to deliver the message. And furthermore, we said that the court will ostracize one who does not respond to a summons only in a case where he comes home on the same day that the woman or the neighbor is sent to deliver the court summons. But if he does not come home on the same day, he is not ostracized because it is possible to say that they forgot to notify him. Rava said, with regard to one who had a document of ostracism written about him due to the fact that he did not come to court, we do not tear up the document for him until he actually comes to court. And it is not enough for him to simply commit to appearing. Similarly, if the document of ostracism was written due to the fact that he did not obey the ruling of the court, we do not tear it up for him until he actually obeys the ruling. And the Gemara comments, this second statement is not so. Rather, once he has acquiesced and said, I will obey, we immediately tear up the document for him. Rav Chisda said the court sets a date for an individual to appear in court on the upcoming Monday. And if he does not appear, they set a date for that Thursday. And if he does not appear, they set a date for the following Monday, so that he has a second date and then a third date after the first date. And if he does not appear in court by the third date, then on the next day, we write a document of ostracism. And by the way, this Monday, Thursday, Monday pattern is no coincidence. We learned this earlier in our journey through the Talmud. Monday, Thursday, Monday, those were the days when people from the surrounding, rural areas would come to town. These were the market days, right? So this is when people were selling produce in the town, when the farmers were bringing produce, when the shepherds were bringing produce, and when the judges would set up the court and cases would be heard. And These are the days when the Torah would be read in the synagogues, and they still are, right? Just today was Thursday, so we read just the beginning of the Torah portion, like we do on Monday. Monday, Thursday, and Saturday, of course, is when we read the Torah in synagogue. And the Gemara relates that Rav Asi happened to come to the house of Rav Kahana, and he saw that there was a certain woman whom Rav Kahana had summoned to appear in court in the evening, but she did not appear. And in the morning, Rav Kahana wrote a document of ostracism concerning her. And Rav Asi said to him, does the master not hold in accordance with that which Rav Chisda says, that the court sets a date for the coming Monday and then Thursday and then the following Monday before it issues a document of ostracism? Rav Kahana said to him, that matter applies only with regard to a man, as he is a victim of circumstance, is not always in the city due to his vocational activities. But in the case of a woman, since she is always in the city, when she does not come to court the first time, she's immediately considered rebellious, and the court may issue a document of ostracism right away. And continuing the discussion of court dates, Rav Yehuda says the court does not set a date for legal proceedings during the days of Nisan, when there's Passover, nor during the days of Tishrei, when it's Rosh Hashanah, Yom Kippur, and Sukkot. And also not on the eve of a festival like Shavuos, nor the eve of Shabbos, because these are busy times. But during Nisan, we may set a court date to take place after Nisan, and likewise during Tishrei, we may set a court date to take place after Tishrei. By contrast, on the eve of Shabbos, we do not set a court date to take place after the eve of Shabbos. And what is the reason for this? It is because one is preoccupied with his work in preparation for Shabbos, and it is possible that he will forget about the court summons. Rav Nachman says, we do not set a court date for participants in the Kala, meaning the gatherings for Torah study during Elul, the last month of the year, before the high holidays in Tishrei, nor in Adar, the month that contains Purim and precedes Nisan, the month of Passover. And that's when these months of Torah gatherings were. And during the months of the Kala, nor for participants in the public discourses prior to the festival, during the period leading up to the festival. And the Gemara relates, when people would come before Rav Nachman during the Kala period, in order to make legal claims against others, he would say to them, did I gather you here for your own needs? No, I gathered you here to participate in Torah study. And the Gemara adds, but now that there are scoundrels who do not come to study Torah, but rather to avoid trial, we are concerned that they will continue to evade prosecution, and therefore we summon them to court even during these time periods. I'm almost done. Questions or comments, please get them in now. So the Mishnah teaches with regard to one who left a stolen item to his children. If the item was something that may serve as a legal guarantee of a loan, the heirs are obligated to pay the owner. And the Gemara states that Rebbe would teach this Mishnah to Rabbi Shimon, his son, and explain that it does not refer only to something that can actually serve as a guarantee for a loan, i.e. land. Rather, it refers even to a cow that he plows with or a donkey that he drives by directing it from behind, which the heirs are obligated to return because of the honor of their father, so that people will not continually point out that the inheritance was stolen and thereby disgrace their deceased parent. So Rav Kahana raises a dilemma before Rav. If the robber left his heirs a stolen item that is used in relative privacy, such as a bed that he lies on or a table upon which he eats, rather than something as conspicuous as a large animal which stands outside the house in which he plows with, then what is the law? Are the heirs obligated to return it to its owner? And Rav said to him, give to a wise man, and he will be yet wiser. Proverb 9:9. Meaning that from the fact that the heirs must return a cow and a donkey, one can infer that they must also return a bed or a table. And that concludes our discussion of Mishnah number 1 here in chapter 10, the final chapter of Bava Kamma. And tomorrow, God willing, we'll pick it up with Mishnah number 2. Friday. Okay. Seeing 2 comments. Sharon, I am assuming that these theft, borrowed, rented relationships are between Jews only. My mind keeps going to items stolen from Jews during World War II in Europe and the generational efforts to get these items back. I mean, these laws generally do pertain right, to the people who will submit to the authority of the rabbinic court. So the laws are a little bit different, right, about legal relationships between Jews and as between Jews and non-Jews. But, if a non-Jew is not going to recognize the authority of a rabbinic court and isn't going to come there, then what's that case going to prove? Now, we're going to start talking tomorrow about this very important legal principle that's in the Talmud, Dina Malchusa Dina, right, that the law of the land is the law. Jews are obligated to respect the laws of the countries in which they dwell. But in terms of, the Nazis seized very valuable artworks, jewelry, gold, all kinds of things from Jews during the Holocaust. And where did that property end up? Some of it, was found in return. A lot of it disappeared. They say that a lot of it is sitting in Swiss banks, right? And the Swiss aren't admitting that they took the deposits from Nazis, and so who gets that property? But taking those people to a rabbinic court, I mean, what's it going to really do? They don't have the authority to enforce rulings against such people. But for example, you have the famous case. It was not having to do with robbery or loans, etc. But you had this case of Spinoza, the philosopher Spinoza, was a Jew in the Jewish community in Amsterdam. All right, so these were Jews who had come up from Spain and Portugal after the expulsion of the Jews, first from Spain, then from Portugal. And so these Sephardic Jews then were in Northern Europe, famous Sephardic community in Amsterdam. And their situation there in Amsterdam was somewhat tenuous, and one of their own starts saying very heretical things, not only against Judaism but against Christianity as well. And he's considered a dangerous person, so they excommunicated Spinoza. Now, does Spinoza care? Yeah, he cared, because it was very difficult for him, right? As a Jew, he had very limited rights in the non-Jewish world. And then the Jewish world excommunicated him, so there were very few people, who would do business with him, interact with him. His life became difficult. So that threat of excommunication, from a Jewish community in the diaspora is a threat with some teeth. Bill, what do we then make of cases where real property can be, if not consumed, then irrevocably altered, right? So we said that in terms of seizing land, we might allow it, where we might not allow the seizure of movable property, because if it turns out that the claim was invalid, the land can be returned, whereas the movable property might have been consumed or lost, and the defendant can't get it back. Bill is making the point that, okay, land will still be there, but what if it's irrevocably altered? So consider this case. A certain subsistence farming family in, let us say, the hill country of Kentucky is cheated out of their land by a mining baron. The mining baron manages to get the court to let him seize the land, and he immediately begins strip mining it. The family then manages to come and bring the documents to prove the baron had no right to it. But now, even if they get the land back, they can no longer farm it. What do we do then? Fine the mining baron? Depending on how much or little he's charged, he might regard it as a cost of doing business. Sadly, the rich, usually have the stronger hand, right? They have all the cards. But it's a good point, and I think that generally we're talking about everyone was in the agricultural situation then. And somebody who sees the land wasn't going to, turn it over and ruin it for the purpose of farming again in the future. But if that were a consideration, who knows? Maybe maybe they quarried it to make stone to go make buildings. It's not so far fetched. Or they dug a canal through it, for the purposes not of irrigation, but of making some kind of a barge way. Right? And now that's going to not be good for the farmers who would rather be farming it. I think if the court were apprised of this possibility, I mean, they would have to issue a ruling or maybe not allow it to take place because of the threat that the land. We see that they care, that the claim could be false and that the defendant needs protection. So if this was a consideration, it sounds like they would probably not allow it for that reason. That's what I've got for us today, and with God's help, we'll be together again tomorrow, Friday, at the regular Friday time, noon Pacific.